Hi, my name is David Gilson. Thank you for joining us today for our discussion on the Renters' Rights Act. My hope is to give you a bit of an overview of the legislation so that you can feel comfortable with the changes that are coming into effect on the 1st of May. Let's get to it. So, this bill, just to give you a bit of a history on it, it was first introduced by the Conservative Party as the Rent Reform Bill and was picked up by Labour when they came into power, renamed the Renters' Rights Act, and predominantly remains unchanged. There's a few tweaks, but it's essentially the same bit of legislation that's seen its way through. It received royal assent before Christmas and has an implementation date of the 1st of May, whereby 80% of the changes will come into effect on that date. So on the 1st of May, the vast majority of this act will come into effect straight away, impacting existing and old tenancies immediately. There is some later stages. So for the second phase, which includes the establishment of the private renters sector property database and the landlord ombudsman scheme, they are expected to be end of 2026, although likely I expect 2027 before implementation. And then they've also given much longer timeframes for the introduction of the Decent Homes Standard to the private renter sector and Awards law. Not really sure why, but dates vary from 2030 to 2035 for expected implementation for those two things. Again, I expect that will be pushed earlier, as I don't really know what's holding that up. So we're going to work our way through the key parts of this legislation. Before we start, firstly, I would like to say that for the landlords we deal with, so in Oxfordshire and surrounding areas, I really don't think that this legislation should cause you too much concern. It is disruptive, it does change things, and it certainly does create a lot more work from our perspective as your agent. But for most landlords working in this area, I don't see any significant changes that are going to impact the income you can expect to receive from your property. So in terms of knowing that that you're in a relatively safe place in terms of the income you receive and aren't going to suddenly have massive changes to that, I think for most landlords there will not be any significant changes. It impacts certain types of landlord more than others. For professional landlords letting to professional couples or families, again, I don't see any massive significant changes here. We're very picky and selective with who rents through us and making sure that referencing is in place and all that sort of stuff, which protects you in that extent. For student landlords, there are more concerns and there are more uncertainties with exactly how things will play out. But I'm confident, as one of the largest agents for student lettings in Oxford, that we can find a way through for our clients and ensure that the properties remain viable and returning a similar, if not greater, return for our clients. At the end of the day, fundamentally, there's nothing in this that will reduce the number of tenants wanting to rent. So I'm confident that we will still be in a place whereby we can always find those good quality tenants. And if anything, it may be that demand increases as a result. So firstly, we're going to talk about the end of no fault eviction. So as it stands at the moment, for most landlords, they're familiar with the term Section 21. Section 21 is kind of the standard for ending tenancy. So if the tenancy's come to an end or is on a periodic basis, if a fixed term's ending or if it's rolled on, a landlord can serve a 2-month notice, which is a Section 21. That notice doesn't require a reasoning or rationale to be given. It's essentially able to be served on any tenant in that situation to bring the tenancy to an end after 2 months' notice has expired. These are the standard mechanism that landlords use to end tenancies more than ever, really. Going forwards, from the 1st of May, that will you'll no longer be able to serve a Section 21 notice. You can serve up until that date. So throughout April, you can still serve Section 21. So if you have a tenancy ending in June, July, you can still serve a Section 21 to a tenancy ending throughout May, June or July. You just have to, if it needs to expire in those months. So it has to expire in May, June or July. And if you intend to go to court with it, If a tenant doesn't vacate at the end of that notice, you have to make sure that you've applied to court for possession before the last day in July, as after that date you will no longer be able to apply for possession from the court. So sort of key things to take away from that are you can carry on using Section 21 for the time being, provided the tenancy is ending in May, June or July. If you do serve a Section 21 and the tenant doesn't vacate, make sure that you've applied to court before the end of July in order to enforce that Section 21 notice. Now, the whole time in the background, we've always had the ability to serve Section 8 notices. Section 8 is not a new thing. It's just, generally speaking, agents don't use it and landlords don't use it because it requires a reason and a rationale for the notice that's being served. Whereas Section 21, no reason is needed. Under Section 8, a reason is needed in order for it to be enforceable. So moving on to Section 8. Section 8s require, as I say, a valid ground and supported by evidence in order to achieve vacant possession. Grounds are split under mandatory and discretionary grounds. So you have Section 8 notices, and then you have to supply the ground at which you're using to regain possession of the property. The mandatory grounds are obviously key because they are the ones that are not open to the court's interpretation. And I've gone into a little bit more detail about a few of the key mandatory grounds to make sure you're aware of those going forwards. So key mandatory grounds, hopefully this is big enough for you to see on your screen. So there's some new grounds that have been brought in as part of this legislation. So there's ground 1, which is a landlord or close family member moving into the property. So this is a mandatory ground, so this is not open to court interpretation, provided that is the case and that you as a landlord or a close family member wants to move into the property. You can give your tenant 4 months notice, and that 4 months notice is finite. You don't have to align that with the tenancy end period. It's 4 months straight notice. And when that notice expires, the tenant is expected to move out from the property. As with Section 21, there's no guarantee that a tenant is going to move out just because notice is served. However, in most scenarios, I'd certainly say in 95, if not higher % of cases, when you serve a notice on a tenant, most tenants will move on. But if they don't move on, at the end of that 4 month period, you would have the right to go to court to get a possession order to move that tenant on at that stage. So as I say, if you're looking to move in yourself or family member, it's 4 months notice. The only key consideration on this is that you are required to ensure that the tenant has been in the property for at least 12 months at expiry of notice. So you can't serve this ground, and it's the same with the next ground I'm going to talk about, 1A. The tenant has a right to a minimum of 12 months in the property. So this ground can only be served as a reason for possession after 8 months have expired. So after 8 months, if you're serving ground 1 or ground 1A, you can give the tenant 4 months notice, so therefore that notice would expire after 12 months have passed. There's also additionally, so ground 1A, just to touch on that quickly, that's your intention to sell. So if a landlord is intending to sell a property, then again, 4 months notice, has to give the tenant at least 12 months in the property before that notice is expiring. So after 8 months, you can serve it and then ask the tenant to move on at that point. But the key thing as well with ground 1 and ground 1A is that if you use these notices to bring the tenancy to an end, you are not permitted to re-let the property for 12 months. So if you use ground 1 or ground 1A, you have to wait after expiry of the notice more than 12 months before you could then get a new tenant into the property. This is to avoid people using these grounds as simple routes to get a tenant out without good reason. So yeah, just something worth being aware of, that if you're serving that notice with an intention to sell, no longer can you test the market for a month or two and then go back to lettings. You would have to be pretty set on the idea of selling because essentially otherwise the property would be sitting empty. Other key grounds that have been introduced as part of these changes, ground 4A, this is a student ground. So essentially, provided your tenants meet the student test, so they are all students at the start of the tenancy, and provided you give them notice that you intend to use this ground, so ground 4A notice before the tenancy started, you can give those tenants notice to end the tenancy between the 1st of June and the 30th of September. Again, you're required to give them 4 months notice, and you can dictate the date at which you wish for them to leave on. Ground 6 is a redevelopment. Again, it's mandatory, so this is for really significant works. So it's where you're carrying out works which would be impossible for a tenant to carry on living in that property. Again, evidence would be required, so plans and details of the work that's planned would be required to be submitted in order to use that ground to bring the tenancy to an end. Ground 7A, that's serious antisocial behaviour. This is where there's potentially criminal convictions or serious situations that have arisen. The notice period is none, so if there is in these circumstances, you can go straight to court to get possession back. And then finally, rent arrears. So this has been slightly changed under the Renters' Rights Act. It used to be that 2 months arrears was what was required, and now it's 3 months arrears. So if a tenant becomes 3 months or more in arrears, you can give a tenant 4 weeks notice that you intend to take the property back via Section 8, Ground 8. And then you could then, if the tenant doesn't vacate and the arrears still exist after that period, you can then apply to the court to bring the tenancy to an end. So it's now 3 months of arrears and then 4 weeks notice to go down that route. So that takes us on to the replacement of fixed-term tenancy. So just to recap on what we've talked about. So we no longer have Section 21. Instead, all tenancies are going to be ended by notice. So the notice can come from a landlord, and as we've talked about, that varies from 4 months to 4 weeks, depending on the notice that's being given. The tenants going forward will have the ability on every single tenancy as of the 1st of May to give 2 months notice to you. So as a tenant in an assured short hold tenancy, they have the ability to give 2 months notice, but their notice must expire at the end of a relevant period. And a relevant period means the dates at which they pay rent. So if they moved into the property on the 15th of the month and they pay rent from the 15th to the 14th of the month, their relevant period is the 15th to the 14th. So therefore, when they give notice, their notice must expire at the 14th of the month. So even if they gave notice on the 1st of May, that notice would essentially not have effect, giving 2 months notice on the 1st of May until the 14th of July, because their 2 months notice must be in line with their tenancy period. So going forwards from the 1st of May, and this is impacting all tenancies, we'll no longer be working to fixed terms. So at the moment, we tend to let properties for 6, 12, 24 months, a fixed term period whereby both landlord and tenant know the term that's been agreed to. Going forwards, there'll be no fixed term agreements anymore. So every tenancy that starts will automatically be a rolling, essentially periodic tenancy from day one. As I say, tenants would be required to give you 2 months notice if they wish to bring that tenancy to an end. And landlords, from your perspective, you'd have to follow one of those Section 8 rules in order to serve notice under one of those grounds that are outlined. There's more grounds, but I've given you the kind of key ones that I think are probably relevant to most landlords. This will, as I say, this will impact all tenancies from day one. So there's no run out period, there's no existing tenancies not impacted. All tenancies from the 1st of May have this ability. And this will obviously change an awful lot. There is concern, obviously, that tenants could move into a property and give notice very quickly, within the first month, to then leave after 3 months. I think in certain cities this may be more frequent than others. I'd say in the markets we work in Oxford and Tame and the surrounding areas, I don't think it's likely with the type of tenant we're letting to that's going to be a major problem. And also I think it probably puts greater importance on the discussions and conversations we have before we start that process to ensure we really understand who these people are, what their purpose for moving is, and obviously making sure referencing all adds up and it all makes sense, that this is not someone looking for a short let and trying to play the system. This is someone looking for a longer term option, because we can still, just as we are at the moment, be picky with who we're letting to and making sure that we're finding someone who hopefully aligns with a landlord's requirements. So most landlords are looking for longer term tenants, and we would carry on trying to find those long term tenants for you with that questioning, with those, with that referencing that we do prior to starting that process. Rent increase are limited to once per year. So going forwards, rather than, because we're not going to have renewal agreements, so because every tenancy entered into will be rolling and just continuous, we're not going to have that natural 12-month point at which we can review the rent, where we put a new contract in place. Instead, every 12 months, we have the right to review the rent with the tenants. And this is done by discussion and then service of a Section 13 notice, which formalises that rent increase. Our intention would be to carry on the process just as we do at the moment, really, with renewals. So establishing that the tenant is happy in the property and all is working out well, confirming that are they keen to likely continue in the property, negotiating a rent which is accepted by the existing tenant, and then service of a Section 13 notice to formalise that change. I think that there's been a lot of conversation about issues that will arise from this. If we move on to the next slide, where we talk about the rent tribunal. So essentially going forwards, there is this right for tenants where they have a rent increase that's proposed to them to go to this tribunal service who would review the rent and make sure that from their perspective it's fair. The problem with this tribunal service is it's quite heavily weighed in the tenant's favour. So the tribunal service will essentially not charge the tenant anything for enacting this and starting this process. They also are a downward only review, so they will not be reviewing the rent upwards because the landlord's been too kind. It would only ever be downwards, and also the tenant doesn't have to pay the new rent until the tribunal has heard and read back on the case. So from a tenant's perspective, it could be seen as very low risk to go down this route. I would say, and there's in the papers inevitably, and in the media, this has been an area whereby there's been a lot of discussion because people have said, oh, every tenant will go through the tribunal process. I think that, in my view, that won't be the case. I think that, in the most part, we have really great relationships with our tenants, and I think that our tenants would see that a landlord is being fair in that scenario whereby we put a rent forwards. We always justify a rent increase. So if we're going to a tenant with a rent increase at renewal, we generally are not encouraging our landlords to push every single penny out of that property. We're going to the tenant going, look, your landlord really appreciates you're a great tenant and has proposed this rent. Are you happy? Can we, normally we can absolutely justify it with comparables if we need to. And we wait for the tenant to come back to us to confirm before we're serving that Section 13 notice. I think that the agents that get caught out and the landlords get caught out on this are the ones who will use the Section 13 as a blunt instrument. So they'll send out a Section 13 without having that pre-discussion with a tenant and without making sure they've built up that relationship whereby the tenant understands where it's coming from. I'm sure we'll have a few that will go through that tribunal process, but I think in the most part it will not be a common occurrence because of the relationships that we maintain with our tenants, and because generally speaking we're working with landlords who are fair about the increases that are put forwards. There's no limit on the rent increase, so if a property is significantly out of sync with the market, there is nothing stopping you from putting forwards a much higher rent increase if it's justified. But I think the key is to make sure it's justified and that we're not pushing above market at that stage. But as I say, I think we can fall back on the fact that we do have a great relationship with our tenants, and in the most part, I don't see this as being of any major concern. Obviously, they are required to carry on paying the rent until the tribunal hears this case. It's just that they wouldn't have to pay the increase. So if the rent was £1,000 and the proposed increase was up to £1,050, until the tribunal has heard the case, they would carry on paying the £1,000, and it would only increase it once the tribunal had given their verdict. This moves us on to the end of bidding wars and rent in advance. So again, part of this act, there is a restriction on the amount of money we can take prior to the tenancy starting. So that's now capped at 1 month's rent. So the maximum we're allowed to take before the tenancy starts is 1 month's rent. This is not of major concern for most landlords, because in most scenarios we take 1 month's rent under deposit and that is it anyway. However, for landlords who are renting to overseas tenants or overseas students, it's quite common that rent in advance is offered as security. So rather than having a guarantor or employment income that we can reference, often tenants moving from overseas will put forward 6 months rent or 12 months rent to secure the tenancy. We will not be allowed to accept that as security anymore. So that won't be on the table. That won't be able to be asked of the tenants at all. So we have to find other ways around it. There are guarantor services which can fill that gap, but they're very expensive for the tenant. So they're not ideal. Essentially, they can charge up to nearly the same amount of money to the tenant for the pleasure of just being an insurance-based product that guarantees their position. as I say, it's one of those situations whereby if it comes up, if it's a topic which we need to discuss with you, at that point we'll have a chat with you about it and make sure you're fully aware of the options that are ahead. But we won't be able to take rent in advance as we have done in the past. So for those of you that have had those lump sums of 6 months or 12 months rent in the past, it won't really be an option anymore. We'll have to be renting. All tenancies essentially will be required to pay rent on a monthly basis. There won't be those lump sum payments anymore. There's also the end of bidding wars. So this is not something which we practice, to be quite honest with you, but some agents, it's particularly common in London, were putting prices out there, but then generating lots of interest and going to best offers. So encouraging tenants just to pay. We've always, I suppose, focused on the importance of the tenant quality, and so not brought it down to being who would pay the most, but it's much more important to make sure we've got the best possible tenant for that property, and so therefore done it on an application basis whereby we're picking who we think is the best fit rather than just encouraging them to pay more. But going forwards, that idea of sort of bidding wars will not be allowed. So essentially the amount that you list the property at will have to be the rent that we accept. Even if a tenant comes along and offers more, we're not allowed to accept it. We have to accept the rent as the listed amount. This likely, to be honest, will just encourage landlords to possibly go marginally above what they thought was achievable in those markets where they were practicing this before. So I'm not sure if it will have the desired effect, but certainly there's nothing in that's going to impact any of our clients. So strengthen protections against discrimination. This is all stuff which, to be honest with you, I don't think, again, will have any impact on our clients. You can not have sort of blanket bans on children or people in receipt of benefits anymore or anything like that, which is not something which we do. We don't have those sorts of policies. Every tenant is based on their own credits in terms of their affordability, etc. And that will continue from our perspective. We would continue to put forwards anyone who we thought was, obviously a suitable fit or could meet affordability for them to be considered as a tenant. It also means that you cannot use, because of these changes, some mortgage lenders and some insurance companies previously have had clauses in contracts about not letting to tenants in receipt of DSS. These are no longer valid, so that's not a valid reason for not accepting someone in receipt of housing benefit anymore. That those policies that contain those are essentially automatically cancelled. And don't think it's anything else in that we need to discuss, and nothing else is really of any concern to our clients. Tenants' right to request a pet. So again, this comes down to situations whereby you can't have, again, a blanket ban on no pets. You have to be open to a pet request coming through, and we have to reply within a certain time frame as to the fact that that's being considered. It doesn't mean that you have to accept a pet in every property. It just means you have to give good reason why you're not accepting a pet in certain properties. So, for example, if you've got a block of flats whereby there's one communal entrance, suggesting that it's not suitable to have a dog in that property, I think it's probably fair. If you've got a communal entrance, inevitably there may be someone else in one of the other flats that has allergies, and having the dog walking in and out through that communal entrance may be impractical. Exactly what is a good reason and isn't a good reason at the moment is to be seen. All of this stuff, I expect, over the course of the next 5 years will be tested, and there'll be clearer guidance on what is reasonable and what is not reasonable. But essentially, if we have pet requests in properties, we will discuss it with you. We can't just say no. We have to come up with a reason. We have to consider the request and then feed back to the tenant. So when those situations come, we will have that conversation with you, and then we will report back to the tenant accordingly. So there's no reason to be concerned. In properties that are not suitable for pets, they still will not be suitable for pets. It's just we have to give rationale in that scenario. There will be this in the long run, as I say, from end of 2026, possibly 2027, there'll be this landlord ombudsman, and this is just a sort of thing whereby they can go to the ombudsman to query a denial. So if they put forward a pet request and you put forward your rationale for why that's not not going to be suitable. If they feel that's an unreasonable answer, they could go to this tenant ombudsman, who would look at the evidence and decide between tenant and landlord if it's a fair response that's being given. Tenants are still responsible for pet-related damage, so that's still absolutely, we can charge against their deposit if there's damage caused by having a pet in the property. And then that moves us on to improving property standards. So as I started with, some of the bits of the Renters' Rights Act have been pushed into the distance. So weirdly, the Decent Home Standards and Awards Law, which seem to me like some of the simplest changes of all of this legislation, are, rather than being given a deadline to come in on the 1st of May or the end of this year, have been pushed into the distance. So currently, depending on where you read it, anything from 2030 to 2035 has been quoted as the likely implementation dates of these things, which seems an awful long way away. I think the likelihood is that as things progress over the next year, 2 years, that those timeframes will get a bit shorter. There's no real reason why these changes couldn't come in sooner. So I expect with the implementation of the landlord database, that may well mean that the Decent Home Standards and Awards Law kind of gets pushed along and they all kind of come in together in the end. Just to give you a bit of an overview, so Decent Home Standards currently applies to social housing, and it now will be applying to the private rented sector. Again, not of any massive concern to our clients, particularly those in Oxford have selective licensing and additional licensing anyway, and the properties we look after in Tame and the surrounding villages would have nothing to be concerned about with the Decent Home Standards. Tackling damp and mould. So this is Awards Law. So essentially this is about how we deal with mould when it's reported to us in a property, and we will be given much tighter frameworks and timeframes to deal with such maintenance requests. So we'll have to respond in a certain time frame. We'll have to take action in a certain time frame. Different types of size of issue need to be dealt with different levels of priority, which I think is good for us really, because it allows us to have a bit more structure to how we deal with those situations, and a little bit more kind of I suppose sort of process for it to be to know that we've ticked the right boxes. Then, as I say, the private rented sector database, I've been involved in the government research collection for this. So this is essentially going to be a database of all rented properties and landlords in the UK. My hope is, I've been involved with the Department of Research's data gathering exercise on this, and I understand from that they have a couple of models which they are testing, and the hope is that they allow us as much as possible as landlords, as agents of managed property, to deal with this on your behalf, and I was very much heavily pushing that idea that there should be nothing really that we can't do on your behalf. As with selective licensing and additional licensing, make it a structure whereby you can sign off but we can submit, and fingers crossed that's what they come up with when the framework is announced. I understand they're testing it in various boroughs in London at the moment with a few agents to see how that goes. And then, as I say, the new ombudsman services, this is again going to be end of this year that it should be coming in, and that's essentially free, independent sort of I suppose third-party decision-making whereby there's a dispute between tenant and landlord, and yeah, we'll see how that comes into fruition when there's more information on it in due course. So hopefully that gave you a good overview. Obviously, there's certain aspects of this legislation which I haven't gone into in any detail. One thing I thought would be worth, for those of you that want to carry on listening, just kind of retouching on was the Section 4A notice for student landlords. So this is a key area whereby it's a bit confusing because on paper it sounds like, oh great, landlords of student properties can serve notice and fix an end date to a tenancy, so therefore we can carry on working the way we're working. I think the problem with it is that yes, you can fix an end date. So yes, provided you've given the tenants advance notice of your intention to use the ground 4A, and that your tenants meet the student test, so they are all in full-time education, that you can serve that notice and you can formalise the end date as the 1st of August or whatever you want to, and then you can line up a new tenancy group from the 7th of August or whatever your structure is. The problem is, because you've served notice on the tenant doesn't stop them being able to serve notice on you. So there's still this risk that if you serve notice to a date that the tenants have decided actually they would like to leave a bit earlier than that, they can still give you notice to leave earlier, which could result in a void. It's a big issue for this year because we don't have the ability to serve notice this year. So those student landlords that we work with in Oxford have been, we've discussed this with them and sent emails about this already. So this hopefully is relatively familiar. But this year we don't have the ability to serve a Section 21 or a Section 8 notice on any tenancy ending in August. Obviously, most tenants will leave that have told us they're leaving. So I don't think there's many problems in terms of them staying beyond their tenancy end date, because students don't. Generally speaking, they will leave because their intention is to leave. The problems will arise from if there may be a few of them that want to leave earlier than those end dates, and they could give us notice in early May. Going forward, the way that I see it best worked is that our intention is to, this year with the student lets, we've contacted them, we've asked them if they want to advise us of an earlier end date. So the groups that want to leave, want a 10-month or 11-month tenancy, there is no sense in saying no to those. If tenants confirm to us now, actually, yeah, we would like the property until the middle of July, great. We know that we've got a much better chance of that being the date at which they want to leave on, and so we can then serve notice to that date, line up a new tenancy group, and we have a much lower risk that they're going to end up wanting to go before that. Originally, when this was all discussed, there was a lot of landlords who were really worried about this idea that tenants would all want to leave in May and June. I can honestly say that we've let over 100 properties for students for next year, asked them when they want their tenancies to end, and one or two have mentioned June, but the vast majority have mentioned July and August as their ideal turnaround times. It's not at all that all tenants are wanting to leave day after university finishes. So I don't think it's likely that loads of tenancies will be given notice to leave in May or even early June. I think generally speaking, things may move into a kind of end of June, early July or mid-July sort of time frame, and it may bottleneck us slightly more so that there's higher numbers of turnaround in a shorter period of time over those months. But those tenants that obviously have moved will be moving in this summer. We will explain to them these changes. We'll explain to them our ability to give them notice, and we'll ask them if they could confirm a date that they would like to stay until, and we'll serve notice based on that date. So we'll contact them in October. We'll say, look, the landlord has the ability to serve notice under Section 8, Ground 4A. What date would you like to stay until? And we'll serve notice to that date, and then we'll align a new tenant based on that date. I think working that way will give us every chance to really minimize those possibilities of groups wanting to leave before that date. There still will be the odd one. I do think it will be the odd one, whereby they have a situation, if the tenants fall out, or if they've had some significant maintenance issues that have had problems over the course of the year and not been able to be resolved. Those sort of scenarios might result in a group deciding actually they're going to go earlier than they had initially given us a date for, but I think it will be rare. And I think what will happen is a lot of groups will say, oh yeah, could we confirm it for July? Or July or end of June or early August or whatever it is, and then it gives us a date to work towards. But as and when those are relevant, we'll give you more information on that and discuss that more at the time. But I'm confident that we can find a way through. The market for student properties this year probably was busier than ever in terms of levels of demand, and I don't see that changing at all. I think that inevitably this legislation for landlords who don't have agents giving them the support and the kind of the knowledge base to make informed decisions is scary for some, and so some landlords will inevitably try and exit the market and put their properties on to try and sell, which will diminish the student stock. So the demand for student stock will only go up, and realistically, supply and demand does mean that rents will likely carry on going up as well. So I have every confidence we can find a way through. Do come back to me after watching this if you've got any questions or concerns or anything you'd like to discuss further. Always really happy to have a chat, so feel free to get in touch. And hopefully this was interesting. As and when there's more information on the next phase coming in at the end of 2026, I will do a further update for you. And yeah, we'll look forward to continuing to work with you, and the team are there to answer any questions you have. Thanks a lot. Thanks. Bye.